Welcome to Ask the Lawyer, International Edition, the radio show that brings you the latest trends in immigrating to the United States. Hosted by attorney Brian Figueroa of the law firm Figueroa and Associates. This program is designed to provide valuable insights for those who wish to live, work, study, or invest in the U.S. Whether you're an international student seeking educational opportunities, an entertainer looking to break into the U.S. market, or a business owner wanting to expand your operations and tap into the vast U.S. economy, this show is for you. If you're an investor exploring options in the U.S. or someone with family or friends already living here, you won't want to miss the important information shared on Ask the Lawyer, International Edition. Each week, we dive into critical topics that help you navigate the complexities of U.S. immigration and business law. Special guests include experts in business development, elected officials supportive of immigration, business owners, and nonprofit leaders who provide real-world advice and guidance for those wanting to build a future in the U.S. The law firm of Figueroa and Associates was founded not only to serve our clients, but to contribute to the greater good. We understand the importance of helping individuals and businesses achieve their American dreams, and we are committed to providing the legal expertise and support needed to make that happen. So whether you're an entrepreneur looking to open a branch of your business in the U.S., an investor ready to explore opportunities, or someone hoping to migrate and build a new life in America, you should tune in and learn from this informative program. Ask the Lawyer. International Edition is your resource for understanding U.S. immigration trends, business opportunities, and legal strategies. Call now. For personalized legal advice, contact the experienced attorneys at Figueroa and Associates today. Our team is here to help you navigate the path to success in the U.S. Thank you for listening to Ask the Lawyer, International Edition with attorney Brian Figueroa. Visit us online at askthelawyer.us or call today to schedule your consultation.
Good day, good day, good day. My name is Brian Figueroa of the law firm Figueroa and Associates. This is Ask the Lawyer. You got question, we got answer. The number to call, the number to keep, the number to share is 855-768-8845. Again, 855-768-8845. Wow. We need responsible leaders. We need them in Washington. We need them in New York. We need them in California. We need them in Brooklyn. We need them in Port of Spain. We need them in Kingston, Jamaica. We need them each and everywhere in the world. Because obviously elected officials have the impact to impact, obviously, people's daily lives, their livelihood, and obviously things like health issues, issues related to the young ones, children in school, the decisions that they make, whether it be budgets or whether it be what we call aid, i.e. assisting other people. Charity. What does charity mean? Love. And in modern times, in past times, wherever, countries dominate, individuals dominate with their wealth and influence. And obviously, one of the most important things is character, good moral character. What does that mean? That's one of the requirements to be a green card holder in the United States or to become a U.S. citizen. Good moral character. So, because you're born in America doesn't mean you have good moral character, or in Port of Spain, or in Kingston, or in Ghana, or in Brazil, whatever. What makes good moral character? And unless I am blind or deaf or whatever, does President Trump have good moral character? Does the mayor of New York City have good moral character? Does the Prime Minister of Trinidad and Tobago, the DR, Somalia, the Congo, Do they have good moral character? So whether you listen to this program, you tune into the BBC, you look at CNN, you look at MSNBC, you look at publications, foreign, international, local, whatever, the biggest issue most times discussed is good moral character. The article doesn't say this is an analysis of good moral character in a publication, or when you listen to someone on radio, TV, whatever, wherever you get your news and views. But the discussions in your mind is giving you information so that you could determine whether or not there's good moral character in this initiative or that law that has to be passed or revoked or whatever. Good moral character. One of the oldest books we have for humanity is the various religious books that exist. And all of them, starting with the Ten Commandments, they talk about good moral character. You have to have good moral character to hang out with God in heaven. And if you lack it, you could hang out in hell with Satan, where there's a lot of heat. And I'm from the tropics. I like heat, but not that type of heat. Yeah. So, good moral character. I mean, it's in relationships too. It's why people get divorces. It's why people stay together. It's why people have children. Good moral character help you determine, obviously, what is good and what is bad. I'm not a rocket scientist. I'm just a lawyer who are very well qualified. And if we look at what is happening in the leadership ranks in the United States of America, we see a lack of good moral character. And what is the consequences of a lack of good moral character? So, for example, U.S. aid that one of the richest men in the world is destroying, Elon Musk, a white boy I really never liked. To me, he's the second, or I should say the third or the fourth coming of Satan. There are a lot of people competing for number one, Satan. And he decides, look, let me dismantle the U.S. aid. He laughs, he tweets, and he has this indifference to people. He has an indifference to people, obviously, with lower income, and everyone has lower income than him. Lesser capital. Nobody has more capital than him. Yet still, all the wealth he has accumulated, all the income that he has, is he going to end up with Satan, the devil, in hell, in heat, roasting away. My name is Brian Figueroa of the law firm Figueroa & Associates. This is Ask the Lawyer. You got questions, we got answers. The number to call, the number to keep, the number to share is 855-768-8845. Again, 855-768-8845. So who is defending us from Satan? And what would God want you to do? Obviously, vote properly, be charitable, give to the poor, accumulate wealth, fine, but still, obviously, how much are you going to take with you? So these are some of the issues that humanity has had for decades, centuries, time memorial, and a lot of it hasn't changed. So because of the destruction of U.S. aid by Elon Musk, now I call Trump, KKK Russian Trump, what should I call Elon Musk? Can someone suggest something? But because of him, 6 million people that are HIV positive in the world will die. A lot of kids, a lot of children. And when U.S. aid spends money, that's a U.S. agency, on impacting issues like HIV, every single medicine is bought from U.S. businesses. U.S. aid doesn't take billions of dollars and say, let me buy Chinese goods or services or Trinidad and Tobago goods or services. U.S. aid gets everything from American businesses. So when you cut billions of dollars from U.S. aid, it takes away from businesses that could have better margins, be more profitable in the world in terms of international trade, global business. So essentially, KKK, Russian Trump, and Elon Musk, they're supposed to be able to make money, but can they really? Do they have smart people working for them that help them make money? Like them kids Musk have working for him? But if their issue is money, it is stupid. But if their issue is punishment in disregarding wealth for America, then these guys, are they the coming of the, what do you call it, the Antichrist? I'm not taking a religious tone. I'm just using all the information out there available to me. Whether it be legal analysis, issues of good moral character, or looking at the various religions and what have you, beliefs that exist in humanity. Many organized churches in America supported KKK Russian Trump. And by supporting KKK Russian Trump, they thought that, okay, well, maybe he will have smart or people with good moral character around him. And obviously, that is not happening. So what are the people supposed to do? Again, my name is Brian Figueroa of the law firm Figueroa & Associates. This is Ask the Lawyer. You got questions, we got answers. The number to call, the number to keep, the number to share is 855-768-8845. Again, 855-768-8845. So when we think about our client, when we think about our colleagues, when we think about all the various people that we have helped in this country, Brooklyn, New York, the law firm of Figueroa & Associates, and the minds that we have touched through our publications, we feel good about the job that we have done. And there's nothing better than the satisfaction of helping people. Again, my name is Brian Figueroa, the law firm Figueroa & Associates. This is Ask the Lawyer. You got questions, we got answers. The number to call, the number to keep, the number to share is 855-768-8845. Again, 855-768-8845. Visit our website, the law firm of Figueroa & Associates, at www.askthelawyer.us. www.askthelawyer.us. When you visit that website, there are going to be links to many articles that we believe could make your life better, whether from a legal perspective, or economic perspective, or understanding the society that we live in. At the law firm, you're not just a client, you're a person, you're a friend, you are a human being. And that's how it should always be for everyone. Thank you.
Do you have a family member overseas that you want to bring to the United States? The law firm of Figueroa & Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in family-based green card petitions, guiding you step by step through the process to reunite you with your loved ones. Whether you're a U.S. citizen or a green card holder, we will ensure your petition is handled smoothly and efficiently. Plus, we can help you understand how filing for a green card may impact your relative's visitor visa. Schedule a consultation today. Visit askthelawyer.us or call 855-768-8845 to discuss your case with our skilled legal team. Figueroa & Associates, your trusted partner in family immigration law.
If your spouse has overstayed their visa and you want to help them obtain a green card, we can help. The process of adjusting status can be complex, especially if there was an overstay, but the law firm of Figaro and Associates, located in Brooklyn, New York, has the experience and expertise to guide you through it. Our team of immigration lawyers will assist you every step of the way, from filing petitions to representing you at interviews. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845. Get the right legal help when it matters most.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father, Brian Figueroa.
Good day, good day, good day. My name is Brian Figueroa of the law firm Figueroa and Associates. This is Ask the Lawyer. You got questions, we got answers. The number to call, the number to keep, number to share is 855-768-8845. Again, 855-768-8845. Religious petitions, immigration, yes. There are so many different churches in America representing people of color. And those churches are entitled to petition for religious workers. Every year, there's a quota of 10,000 green cards. However, that quota is never exhausted, which means you churches out there, you religious organizations, you are not using this special immigrant visa to bring your fellow religious leaders from the diaspora, the African, the Latino diaspora. So whether it be Latin America, Africa, the Caribbean, wherever, if you have an organized church, you can petition for religious workers from those countries to help you do your job here in America, which is spreading the word of God. Yes. And we know God has different, meanings, but U.S. immigration law does not, discriminate against any particular religion. So we're talking about all religious organizations that are 501c3 approved, meaning they are a bona fide nonprofit. So if you are a religious leader and you want to bring that pastor, evangelist, organist, whatever it is that is categorized as a religious worker, no non-religious work, please, and you want to bring that person to America, give us a call. And we will work with you to bring that person or persons to America so that God's word would be, properly taught. My name is Brian Figueroa of the law firm Figueroa and Associates. This is Ask the Lawyer. You got questions, we got answers. The number to call, the number to keep, the number to share with your religious leaders, churches, synagogue, whatever your religion. It's 855-768-8845. Again, 855-768-8845. Many religions established in the United States of America or imported from other countries, they have the right to religious freedom in America. And obviously sometimes the big guy or lady who really understands and can motivate people to God, they are what? In other countries. But you could bring them here. You could get them a green card. You could bring their families here so that they could make a transition to America in a much needed leadership position. Again, the number to call, the number to keep, the number to share is 855-768-8845. Again, 855-768-8845. Our website, www.askthelawyer.us. Again, www.askthelawyer.us. askthelawyer.us. Thank you.
Attention green card holders. Have you been outside the United States for more than a year? Are you holding an old green card without an expiration date? These situations can jeopardize your permanent resident status. At Figueroa and Associates, we specialize in immigration law and can guide you through these complex issues. We are located at 26 Court Street, Suite 701, downtown Brooklyn. We are here to help you navigate the legal maze. Don't wait until it's too late. Call us today at 855-768-8845 to schedule a consultation. Protect your status and secure your future with Figueroa and Associates. Figueroa and Associates, your trusted partner in immigration law. Call 855-768-8845 now or visit askthelawyer.us to schedule.
Do you have a family member overseas that you want to bring to the United States? The law firm of Figueroa and Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in family-based green card petitions, guiding you step by step through the process to reunite you with your loved ones. Whether you're a U.S. citizen or a green card holder, we will ensure your petition is handled smoothly and efficiently. Plus, we can help you understand how filing for a green card may impact your relative's visitor visa. Schedule a consultation today. Visit askthelawyer.us or call 855-768-8845 to discuss your case with our skilled legal team. Figueroa and Associates, your trusted partner in family immigration law.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father, Brian Figueroa.
Our weekly immigration news roundup is brought to you by the law firm of Figueroa and Associates. For a consultation on any immigration or legal matter, please call 855-768-8845. That's 855-768-8845. For full stories and more immigration news, visit www.theimmigrantsjournal.com. That's www.theimmigrantsjournal.com.
Hello, my name is Mary Campbell, legal assistant at the law firm of Figueroa and Associates, and your presenter with a special immigration report.
Historical context of Guantánamo Bay. Detention practices and modern immigrant rights under President Trump. Guantánamo Bay, located on the southeastern coast of Cuba, has been under U.S. control since 1903. Its detention facility gained international attention post 9/11 when it was used to hold individuals captured during the War on Terror. The choice of Guantánamo was strategic, aiming to place detainees outside the jurisdiction of U.S. federal courts. Over the years, the facility has been synonymous with human rights violations, including indefinite detention without charge, lack of due process, and reports of torture. These practices have been widely condemned by international human rights organizations and have led to numerous legal challenges. Legal framework governing detainee rights at Guantánamo Bay. The legal status of Guantánamo Bay detainees is complex, influenced by a combination of U.S. constitutional law, international law, and specific legislative acts. U.S. constitutional protections. In the landmark case of Boumediene versus Bush, 2008, the U.S. Supreme Court held that detainees at Guantánamo have the constitutional right to file writs of habeas corpus in federal court. This decision affirmed that fundamental rights afforded by the Constitution extend to Guantánamo detainees, allowing them to challenge the legality of their detention. International human rights law, international treaties such as the International Covenant on Civil and Political Rights, ICCPR, and the Convention Against Torture, CAT, to which the U.S. is a party, impose obligations to uphold the rights of all individuals under its jurisdiction. These include prohibitions against torture, the right to due process, and the right to a fair trial. Detention practices at Guantanamo have been criticized for violating these international norms. Recent legislative and executive actions. In recent years, executive actions have expanded the use of Guantanamo Bay for detaining immigrants. The Trump administration's policy to transfer immigrants to Guantanamo has been met with legal challenges and widespread criticism. Advocacy groups argue that these actions violate both constitutional and international law protections. Rights of immigrants detained at Guantanamo Bay. First, right to legal representation. One of the most fundamental rights of immigrants facing deportation or asylum proceedings in the U.S. is the right to an attorney. However, at Guantanamo, this right is severely restricted. Limited access. Unlike on U.S. soil, where immigrants can retain legal counsel, detainees at Guantanamo face barriers in communicating with lawyers. Denial of attorney-client privilege. Even when legal visits are allowed, attorney-client communications may be monitored or restricted. Lack of legal aid organizations. Most immigrants in detention rely on non-profit legal aid groups, which have no established presence at Guantanamo. Legal challenges have been filed to demand greater access to attorneys for immigrants detained at Guantanamo, arguing that these restrictions violate constitutional due process protections. 2. Right to seek asylum and protection under international law. Under U.S. immigration law and international treaties, individuals fleeing persecution, war, or violence have the right to seek asylum. However, asylum seekers detained at Guantanamo face barriers to exercising this right. No standard asylum hearings. Immigrants at Guantanamo are often not given timely hearings before an immigration judge. Inability to present evidence. Asylum seekers may be denied the opportunity to present evidence of persecution. Forced repatriation risks. Without fair hearings, some asylum seekers may be forcibly returned to countries where they face persecution, a violation of the principle of non-refoulement under international law. Immigration attorneys argue that the U.S. government cannot evade its legal obligations by detaining asylum seekers at Guantanamo. 3. Right to habeas corpus and due process. In Boumediene v. Bush, 2008, the U.S. Supreme Court ruled that detainees at Guantanamo have the right to file habeas corpus petitions to challenge their detention. However, immigrants held at Guantanamo face significant legal obstacles, restricted access to federal courts. Unlike immigrants on U.S. soil, detainees at Guantanamo may not have direct access to U.S. federal courts. Lack of transparency. The U.S. government has not disclosed full details about the legal status of immigrants held at Guantanamo. Delayed or denied petitions. Some legal challenges have been delayed for years, leaving immigrants in indefinite detention. Immigration advocates continue to file lawsuits demanding that detainees at Guantanamo receive the same constitutional protections as immigrants detained on U.S. territory. Challenges in enforcing immigrants' rights at Guantanamo. Despite the existence of legal protections, immigrants detained at Guantanamo face unique challenges in asserting their rights. 1. Jurisdictional and legal loopholes. The U.S. government has historically used Guantanamo's location as a legal loophole to argue that constitutional protections do not fully apply. This argument has been rejected by the Supreme Court, but enforcement remains inconsistent. 2. Political and national security concerns. Guantanamo remains highly politicized, making legal reforms difficult. Some policymakers support expanding Guantanamo's use for immigration detention, citing national security concerns. 3. Lack of public awareness and advocacy. Compared to detention centers on the U.S. mainland, Guantanamo receives less media attention and public scrutiny, making it harder for advocacy groups to mobilize support. Legal strategies for representing immigrants at Guantanamo. Attorneys seeking to represent immigrants detained at Guantanamo can take the following legal steps. Step 1. File an emergency petition for habeas corpus. Demand immediate judicial review of the detainee's immigration status. Request access to legal counsel under Boumediene v. Bush. Step 2. Challenge detention through federal court. Argue that detention violates the Due Process Clause of the U.S. Constitution. Cite violations of U.S. asylum laws and international treaties. Step 3. Advocate for policy changes. Work with human rights groups to pressure Congress to provide greater legal oversight of Guantanamo's immigration detentions. Push for legislation to prohibit the indefinite detention of immigrants at Guantánamo. Step 4. Use international legal mechanisms. File complaints with the United Nations Human Rights Committee. Appeal to international human rights courts to demand access to due process for detainees. The fight for immigrants' rights at Guantánamo must continue. Guantánamo Bay has become a legal battleground for immigration rights, with detainees facing limited access to legal representation, restricted due process, and barriers to asylum. While past Supreme Court rulings have affirmed some constitutional rights for Guantánamo detainees, the U.S. government continues to exploit legal loopholes to deny basic protections. To ensure justice, attorneys, human rights advocates, and policymakers must work together to demand full access to legal representation for detainees, push for federal court oversight of immigration proceedings at Guantánamo, expose human rights abuses through media and advocacy campaigns. Without immediate action, Guantánamo will remain a legal black hole where immigrants are denied the fundamental rights guaranteed under U.S. and international law.
Are immigrants detained at Guantánamo Bay being denied their legal rights? The answer is alarming. Many asylum seekers and detainees are trapped in legal limbo with no access to attorneys or fair hearings. But they still have rights, and we can help. At Figueroa & Associates, we fight for due process, legal representation, and justice for immigrants, no matter where they are detained. If you or someone you know needs legal help, call us today at 855-768-8845 or visit www.askthelawyer.us for a consultation. No one should be left in a legal black hole. Stand up for immigrant rights with Figueroa & Associates, where justice has no borders.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father, Brian Figueroa.
Hello, my name is Mary Campbell, legal assistant at the law firm of Figueroa & Associates, and your presenter with a special immigration report based on an article by attorney Brian Figueroa. The impact of President Trump's executive orders on political asylum applications, pending and new cases procedural analysis. Introduction. The U.S. asylum system has long served as a beacon of hope for individuals fleeing persecution, violence, and human rights violations in their home countries. Governed by both domestic laws and international treaties, the asylum process provides protection to those who meet the legal definition of a refugee, someone unable or unwilling to return to their home country due to persecution based on race, religion, nationality, membership in a particular social group, or political opinion. Executive orders, EOs, play a crucial role in shaping asylum policy by allowing the president to bypass Congress and directly implement changes to immigration enforcement and processing. During his tenure, President Donald Trump signed a series of executive orders that significantly altered the landscape of political asylum in the United States. These policies aim to curb immigration, strengthen border security, and restrict eligibility for asylum, leading to profound impacts on both pending and new asylum applications. This article aims to analyze how Trump's executive orders affected the procedural aspects of political asylum applications. We will examine the influence on cases already in process as well as newly filed applications, addressing critical issues such as processing delays, eligibility restrictions, legal challenges, and the broader implications for the U.S. immigration system. Key executive orders affecting asylum policies. President Trump's administration introduced several executive orders targeting immigration, many of which directly impacted asylum procedures. The most significant orders include 1. Executive Order 13,767, Border Security and Immigration Enforcement Improvements, signed on January 25, 2017. This EO aimed to enhance border security and reduce illegal immigration. It called for the construction of a border wall, increased detention capacity, and stricter enforcement of immigration laws. This order directly impacted asylum seekers by expanding expedited removal proceedings, limiting parole options for asylum seekers while awaiting case adjudication, increasing the deployment of border enforcement officers. 2. Executive Order 13,780, protecting the nation from foreign terrorist entry into the U.S., commonly known as the travel ban. This order restricted entry from several Muslim-majority countries and introduced extreme vetting measures. Though primarily focused on visa applicants, it indirectly impacted asylum seekers from affected countries by prolonging processing times and increasing scrutiny of their applications. 3. Executive Order 13,841, Family Separation Policy and Zero Tolerance. Issued in June 2018, this controversial policy aimed to deter illegal immigration by prosecuting all individuals who crossed the border unlawfully, resulting in widespread family separations. Asylum-seeking families were heavily affected, as children were separated from parents and legal procedures were delayed or complicated by the separation process. 4. Additional executive actions. Beyond formal EOs, the Trump administration implemented other policy changes, such as the Remain in Mexico program, migrant protection protocols, which forced asylum seekers to wait in Mexico while their cases were processed in U.S. courts. The administration also sought to redefine eligibility criteria, making it harder for individuals to qualify for asylum. Impact on pending political asylum applications. The implementation of these executive orders had profound consequences on pending asylum applications, exacerbating an already strained system. Some key impacts include 1. Increased backlog and delays. The asylum backlog surged during the Trump administration, with cases taking years to be processed due to new enforcement measures. The introduction of policies such as last in, first out processing further complicated the situation, forcing older cases into indefinite limbo. 2. Enhanced vetting measures. Executive orders imposed stricter background checks, increasing the burden of proof on applicants. Individuals were required to submit more comprehensive documentation, which led to procedural delays and increased scrutiny, often resulting in denials based on technicalities. 3. Administrative challenges and increased rejection rates. The denial rates for asylum cases rose significantly as adjudicators applied more rigid criteria and interpreted asylum laws more narrowly, particularly regarding claims related to gang violence and domestic abuse. 4. Impact on legal status and work authorization. Many pending applicants face difficulties in renewing work permits and maintaining legal status while awaiting decisions, putting them at risk of deportation and economic hardship. 5. Access to legal representation. Asylum seekers encountered greater obstacles in securing legal counsel, with many nonprofit organizations overwhelmed by the influx of cases and changing policies that made representation more complex. Impact on new political asylum cases procedurally. For new asylum applicants, the Trump administration's policies presented additional hurdles and procedural changes that reshaped the application process. 1. Stricter eligibility criteria and credible fear interviews. The administration imposed tougher standards on credible fear interviews, which serve as the initial screening for asylum seekers at the border. Applicants had to demonstrate a higher likelihood of success in their full asylum hearing, leading to an increase in expedited deportations. 2. Changes to expedited removal proceedings. Under Trump's executive orders, the scope of expedited removal was expanded, allowing immigration authorities to deport individuals without a hearing before an immigration judge if they fail to prove their eligibility at the border. 3. Third country agreements and Remain in Mexico policy. Agreements with countries like Guatemala, Honduras, and El Salvador forced asylum seekers to apply for protection in those countries first before seeking asylum in the U.S. The Remain in Mexico policy subjected applicants to prolonged stays in dangerous border cities while awaiting hearings. 4. Denial rates and narrowing of persecution definitions. New guidelines redefine what qualifies as persecution, excluding claims related to gang violence, gender-based violence, and economic hardship. This change resulted in higher rejection rates and a significant decline in asylum grants. 5. Impact on vulnerable populations. Women, children, and LGBT+ individuals faced increased difficulty in accessing asylum protections due to the restrictive interpretations of asylum laws, leaving many at risk of harm. Legal challenges and responses to Trump's asylum policies. The executive orders issued by President Trump faced numerous legal challenges from advocacy groups, states, and international organizations. 1. Major lawsuits against asylum policies. The American Civil Liberties Union, ACLU, and other legal groups filed multiple lawsuits challenging policies like the travel ban and family separation, arguing that they violated constitutional and humanitarian protections. 2. Court rulings and injunctions. Federal courts frequently intervene to block certain provisions of Trump's asylum policies, though the administration continued to appeal decisions, creating legal uncertainty for applicants. 3. Advocacy and public response. Human rights organizations and immigrant advocacy groups mobilized to provide legal aid and public awareness campaigns to counter the negative impacts of restrictive asylum policies. 4. Congressional efforts. Some members of Congress introduced legislation to counteract Trump's asylum restrictions, though these efforts faced significant political resistance. Comparative analysis. Asylum policies before and after Trump won. Obama-era policies versus Trump's changes. The Obama administration focused on balancing enforcement with humanitarian concerns, whereas Trump's policies prioritized enforcement over protection. 2. Impact on the asylum system's integrity. The restrictive measures introduced during Trump's tenure led to a decline in asylum grants and an increase in procedural complexity, fundamentally altering the system. 3. Reversal of policies post-Trump. The Biden administration took steps to reverse many of Trump's policies, including terminating the Remain in Mexico program and reinstating more lenient asylum processing measures. Conclusion and future outlook. Trump's executive orders had a lasting impact on political asylum procedures in the U.S., creating challenges for both pending and new applicants. The increased scrutiny, procedural hurdles, and policy shifts resulted in longer processing times, higher denial rates, and greater hardships for vulnerable populations. Moving forward, policymakers must find a balance between national security and humanitarian obligations to restore fairness and efficiency to the asylum system. Comprehensive immigration reform, improved processing efficiency, and enhanced legal support for asylum seekers will be critical in rebuilding trust and ensuring the system remains a refuge for those.
Have you or a loved one received a notice to appear, or NTA, to face immigration court? Don't face this alone. Deportation is not the end of the story. There are defenses available to protect your rights and your future. Join Figueroa and Associates for a free seminar to learn how to challenge NTAs and defend against deportation. Led by experienced immigration attorneys, this seminar will cover essential topics like procedural challenges, cancellation of removal, derivative defenses, and recent case law developments. Figueroa and Associates is here to fight for you. With over 25 years of experience in immigration law, our team is dedicated to helping immigrants protect their rights and stay with their families. Register for the seminar today at www.askthelawyer.us. That's www.askthelawyer.us. Don't wait. Seats are limited. Call us at 855-768-8845 or 718-222-3155 for more information. Again, that's 855-768-8845 or 718-222-3155. The law firm of Figueroa and Associates, located at 26 Court Street, Suite 701, Brooklyn, New York. Your future is worth fighting for.
Are you a lawyer with a degree from the Caribbean who dreams of practicing law in New York? The path to becoming licensed in the U.S. can be challenging, but Figueroa and Associates is here to help. Located in Brooklyn, New York, our team specializes in guiding foreign-trained lawyers through the bar admission process. From prudential evaluation and additional legal education to bar exam preparation and fulfilling pro bono requirements, we're with you every step of the way. Let us help you turn your ambition into reality. Visit us at www.askthelawyer.us or call 855-768-8845 to schedule a consultation. Don't let the complexities of the U.S. legal system hold you back. Contact Figaro and Associates today.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father, Brian Figueroa.
The Violence Against Women Act, VAWA, provides a pathway for survivors of domestic abuse to apply for immigration relief without relying on their abusive U.S. citizen or lawful permanent resident, LPR, spouse, parent, or child. VAWA allows these individuals to self-petition for a green card if they can demonstrate they were subjected to battery or extreme cruelty. However, many individuals seeking VAWA relief may have had their marriages annulled, either by their own action as the plaintiff or by their abuser as the defendant. This raises an important legal question. Does an annulment prevent a person from filing a VAWA petition? The answer depends on several factors, including the timing of the annulment, the reason for the annulment, and whether the marriage was legally valid before annulment. This article explores these issues in depth. Understanding the legal concepts, annulment versus divorce. What is an annulment? An annulment is a legal decree that declares a marriage void or voidable, meaning that in the eyes of the law, the marriage never existed or was never valid. Unlike a divorce, which ends a legally recognized marriage, an annulment treats the marriage as if it never occurred. Common grounds for annulment include fraud or misrepresentation, for example, one spouse lied about their identity, immigration status, or ability to have children. Bigamy, one spouse was already married. Lack of capacity, one spouse was underage, mentally incapacitated, or forced into the marriage. Failure to consummate the marriage due to physical or psychological reasons. What is a divorce? A divorce legally dissolves a valid marriage. After a divorce, the couple is no longer legally married, but their previous marriage remains recognized as legitimate for legal purposes. Since VAWA requires proof of a qualifying marriage, the distinction between annulment and divorce is critical in determining eligibility for a self-petition. How an annulment affects a VAWA application. Because an annulment legally invalidates a marriage, it can create challenges for a VAWA self-petitioner. Annulment may eliminate a qualifying relationship. One of the primary requirements for a VAWA self-petition is that the applicant must have been legally married to the abusive U.S. citizen or LPR spouse. If the marriage is annulled, the law may treat it as though it never existed. As a result, USCIS may not recognize the petitioner as ever having been a spouse of the abuser. Example: Maria, an immigrant, marries John, a U.S. citizen who later abuses her. She seeks an annulment based on fraud because John concealed a previous marriage. Since the annulment retroactively invalidates the marriage, Maria may lose eligibility for a VAWA self-petition because legally she was never married to John. USCIS may consider the intent of the annulment. In some cases, USCIS may still consider an annulled marriage for VAWA purposes if it was entered into in good faith. If the self-petitioner can prove that the marriage was legally valid at the time of abuse, and the annulment was sought due to circumstances beyond their control, such as fraud by the abuser, then USCIS may accept the relationship as valid for VAWA eligibility. However, this is not guaranteed and often depends on how state law defines annulment. Some states provide limited recognition of annulled marriages for certain legal purposes, and USCIS may consider these exceptions on a case-by-case basis. Timing of the annulment matters. The timing of the annulment can be crucial in determining VAWA eligibility. If the annulment occurs before the VAWA petition is filed, USCIS may refuse to recognize the marriage, making the self-petitioner ineligible. If the annulment occurs after the VAWA petition is filed, USCIS may still process the case, since the marriage was recognized at the time of filing. Thus, filing a VAWA application before seeking an annulment may be a safer strategy. How being a plaintiff or defendant in an annulment affects VAWA eligibility. If the self-petitioner was the plaintiff in the annulment. If the self-petitioner initiated the annulment, they may face difficulties proving a qualifying relationship for VAWA. However, they might still be eligible if the annulment was based on fraud committed by the abuser. For example, the abuser concealed a prior marriage. The self-petitioner can show the marriage was entered into in good faith before discovering the fraud. They file the VAWA self-petition before the annulment is finalized. If the self-petitioner was the defendant in the annulment. If the abuser initiated the annulment, the self-petitioner may argue that the annulment was coerced or manipulated by the abuser to avoid legal responsibility. The abuser weaponized the annulment to try and prevent them from seeking immigration relief. The annulment was based on false claims made by the abuser. USCIS may take these factors into consideration when evaluating the self-petition. Alternative options for immigration relief. If an annulment prevents an individual from filing for VAWA, they may still have other immigration options, including U-Visa, available to victims of certain crimes, including domestic violence, who cooperate with law enforcement. T-Visa, available for victims of human trafficking, including forced marriages. Asylum, if the individual fears returning to their home country due to domestic abuse or gender-based violence. Cancellation of removal for battered spouses, available for those in removal proceedings who can prove abuse and continuous physical presence in the U.S. for at least 3 years. These alternative options can provide relief if VAWA is not available due to an annulment. While divorce does not prevent a VAWA self-petition, annulment can create significant obstacles because it legally erases the marriage. If the marriage was annulled before filing, the self-petitioner may lose eligibility because USCIS may not recognize the marriage. If the annulment was initiated by the abuser, the self-petitioner may argue it was a tactic to evade legal responsibility. Timing matters. If the annulment occurs after the VAWA application is submitted, the case may still proceed. Given these complexities, individuals considering a VAWA petition should consult an immigration attorney before pursuing an annulment. In some cases, alternative forms of relief may be available. By carefully navigating these legal challenges, survivors of domestic abuse can protect their rights and pursue the immigration relief they deserve.
Do you have a legal issue, question, or concern? Turn to Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us. You can also register for our paralegal program, get legal news, business consults, or other information on educational issues. Yes, Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us.
This show is a production of IQ Inc. Marketing. If you would like to advertise your product or service on this show to the U.S. and Caribbean markets and through our multicultural publications in New York, please call 866-435-3286 or send an email to info@myiqinc.com.
Thank you for listening to Ask the Lawyer International Edition with attorney Brian Figueroa of the law firm Figueroa & Associates in New York. We hope you enjoyed the show, which featured immigration visitors visa, starting and doing business in New York, entertainment and business visas, religious visas, and much more. Whether you are outside the U.S. or have family in New York, the number to call, share, and keep is 855-768 855-768-8845. That's 855-768-8845. Please schedule a consultation with us at www.askthelawyer.us. That's www.askthelawyer.us. This is Ask the Lawyer, International Edition. You have questions? We've got the answers.